Thank you.
SJC-11428, Commonwealth versus Mario Gonzalez.
Thank you.
Yes, counsel, good morning.
Good morning, Mr. Chief Justice. Good morning, Your Honors. David Keeley for the defendant, Mario Gonzalez. Your Honors, unless the court has other plans for me today, I'd like to begin with the Miranda issue, and then secondly, address the Doyle error. Thirdly, the intoxication instruction, and then 33E, and after that, there's time permitting, I would have a few remarks about the bad acts and the dying declarations. So the claim to silence, Your Honors, after Mr. Gonzalez receives his Miranda warnings, the Officer Cepeda asks him, do you want to tell me what really happened? He says no.
But doesn't, in between that, he talk with Cepeda?
Yes, before,
And he basically gets Miranda, he talks with Cepeda to begin with, pre-Miranda.
correct,
He gets Mirandized after the sergeant says Mirandize him.
correct,
He does that.
right.
And the defendant continues to talk.
No, after Mr. Gonzalez receives Miranda, he's asked again, do you want to say what really happened?
Well,
Because,
isn't he also talking about how he got the scratch again? I mean, isn't there conversation before?
that's before, that's
No, no, I
pre-Miranda.
mean after Miranda. Isn't there other conversation before he's asked this last question?
I think he may have made a remark, he may have repeated that he got the scratch in his nose in a fight. But then Officer Cepeda says to him, do you want to tell me what really happened? At that point, Mr. Gonzalez says no. And I think it's clear the officer considered that an invocation because questioning ceased within moments. He's handcuffed and he's taken out of the apartment.
Okay, so let's just follow that through.
Right.
My understanding is, so they stopped talking, asking questions.
Right.
And then as they're putting him in the holding cell, he starts to talk.
Well, he makes,
Does he make a statement to say, well, she hit me first with a bottle?
right.
That
And
was voluntary.
oh, it's
wasn't it?
unprompted and it's
That
voluntary.
comes in.
That comes in.
Okay.
That comes in, but that, I mean, my argument is that that's not a waiver because he's, his eyes are glassy, he's intoxicated, and he's been injured. And so that's just like a blurting out of, it's like an angry outburst. It's not, it's not a, he's not indicating, Mr. Police Officer, I want to tell you what happened. And so I'm,
I just want to be clear on this.
Right.
You agree that it came from him without anyone saying to him, now, give me a statement?
well, the officer turns away, and then there's the unprompted remark, she smacked me in the face with a bottle first. But I'm arguing that that's not a waiver, that doesn't give Officer Cepeda at the police station permission to say to him once again, tell me what really happened. That's interrogation. I say he should have been re-Mirandized at that point, according to the dictates of Mosley.
Now, there's a question, isn't there, about, at the motion to suppress hearing, that's not what the police officer Cepeda said the nature of the conversation was in the first place, right? And so it's sort of, how do we view what this was at trial? It was unobjected to, nothing was made of it at trial. It wasn't like, oh, big surprise that, all of a sudden this is an unequivocal invocation of his rights.
Right, I
When at the motion to suppress, the Cepeda testifies as to what it was, and it didn't sound anything like an invocation of his rights. And at that point, he's being refreshed by his testimony before the grand jury.
Right, but-
So what do you make of this at trial, which nobody objects to and nobody makes anything of? Isn't it just sort of a rephrasing maybe? Does it really amount to?
I think it amounts to a clear invocation, and I agree that it's somewhat inexplicable. I mean, it doesn't come out at the suppression hearing.
And nobody's challenging him at trial either, that this is something new.
It simply could have been missed, but it was exploited in the Commonwealth's closing argument, so, I mean, it was made use of, which I'll get to. It's there in the record, and I think under the statute 33, that the court needs to take a look at that. I mean, it happened. Officer Cepeda said, when asked, do you want to tell me what really happened, Mr. Gonzalez cuts off questioning. He says no. And again, Officer
And
Cepeda.
then he blurts out.
Well, that's afterward. He's cuffed, he's taken out of the, he's arrested, he's handcuffed, he's taken to the police station. Maybe anywhere from maybe like 10 to 20 minutes go by. And then he's in the holding cell. Officer Cepeda says, look, if you need anything, I'm over here. Cepeda turns and moves away. The unprompted remark, outburst, I call it.
I'll call it a blurt. He blurts?
He blurts it out, yeah, he blurts it out. And so then Cepeda's right, the officer Cepeda steps right back and says, why don't you tell me what really happened, which is an interrogation.
Is it?
Well, that's the
I
question.
say it is. He's looking for the real story, for the incriminating, I mean,
Then the defendant goes on and on and on
Oh,
and
he-
on, never, not another question until asked about the weapon.
right?
At
but-
the end.
Right, but he's been questioned, and he should have received fresh Miranda. I mean, it's the motion judge doesn't address any of this because the motion judge doesn't know that he cut off questioning at the
Well, that's,
apartment.
I guess, the problem. I mean, the motion judge did not have an invocation of silence during the course of the motion hearing.
No, but this court does.
Okay, so, but let's sort of step back. So the motion judge acted correctly in saying no invocation of silence because at the motion hearing, he said, did anything else happen in the apartment? And he said no, and that's not an invocation of silence. So what should happen? The motion judge correctly denied the motion to suppress based on the evidence at the motion hearing, and then at trial, it comes out differently.
Right.
So what's supposed to be done?
I think under the statute, respectfully, Your Honor, that this court can deal with it and correct it.
But if it turned out
and
differently,
correct it.
if it turned out that he had invoked his rights at the motion hearing and then at trial he didn't, you wouldn't say we should choose the trial testimony.
Well-
You would say we're limited to evaluate the motion based on the motion evidence.
I might say that, but the record is what it is, Your Honor, and if the motion judge had known about the invocation at the apartment, the motion judge may have agreed with me now that the blurting out of that remark that she hit me first didn't negate the need for fresh Miranda, for fresh Miranda warnings at that point. So, I mean, it's in the record, I think, and I cite a case from the First Circuit that says that you can look at trial testimony if the motion to suppress has been renewed at the trial and denied, and that's what happened in this case. So, I mean, it's clear, it's in the record, and I think the court has the power, and if I
But
may.
we'd have
and-
to find out a clear invocation of silence. Did you
Well,
make
it's clear, and I
Well,
owed
well, I guess that's the question. I mean, because I'm looking at my notes, and it looks like after he's Mirandized, Cepeda asked the defendant whether he'd asked the victim for a description of the supposed intruder, because that's what he's already told, that there was an intruder. So he talks about that.
I think
He
that will
responds to that he'd been unable to get a description from the victim, so he's telling Cepeda about that after Miranda. And then he states again that the cut on his nose was due to a fight several days earlier. And it's only then, after the Cepeda tells the defendant that the victim was still alive and asks the defendant whether he wanted to tell him what happened, that he says he did not. That's the trial testimony.
Right, and
And
that's-
then, so in a fairly short period of time after that, he's in the holding cell. There's not a long time that goes by.
No, I think there's a timeline I set out in a footnote, it might have been at most 30 minutes from the Miranda until
Right.
until the objectionable statement, challenge statement at the police station.
So basically, he's in, you could look at this and say that he's waived Miranda by talking with the police after getting Miranda, and then makes whatever statement this is that he says at trial that, I don't want to tell you what happened.
Well, I'd ask the court not to interpret that way because you can cut off questioning at any time, and that's precisely what he did. And again,
It's a different sort of standard in terms of, looking at what he's, how clear the invocation has to be, right?
well, according to some of the old cases, I think I cite some cases in the brief, Commonwealth versus Brandt and some of the other cases, the defendants asked, do you want to continue or do you want to talk? And the answer is no.
How do you
It
know that
couldn't
it's
be
not just to that one question he won't answer?
Well, I think Officer Cepeda's reaction lends some weight to the fact that it's an invocation because Officer Cepeda hears no, it ceases, cuffed, out he goes. and he's
But
taken out of there.
But Cepeda doesn't cuff him and take him out.
Oh,
Somebody
I
else
think,
does.
well, Cepeda's, I mean, he's right there. There's several police officers in the apartment. And by the way, Your Honor, the,
By this point, the victim
Miranda
has
and the
been
rest are
removed.
virtually simultaneous, so, I mean, it all happens quickly, and within moments. So, you know, if I could pivot to the, what I, you know, the so-called Doyle era at this point, I don't have too much to say about that, merely that, you know, it comes out at the trial, and, you know, it was the Commonwealth that introduced it. There wasn't any instruction. I mean, there's no objection here. Again, somewhat inexplicable, but it's there. Has to be, I think the court needs to deal with it. And, you know, the Commonwealth does make some hay with it in the closing to suggest that, you know, he's too indifferent to even inquire about how the victim's doing at the hospital. I say that's prejudice, causes some prejudice because it possibly negates the first Cooning factor. There's a possibility, at least, in my mind. And Doyle errors are very serious. It's constitutional. And so I think, as to this issue and my first issue, that a new trial is appropriate for these errors. And unless the court has any questions on that, which is a fairly clear-cut issue, I believe, I'd like to turn to the
Yeah,
intoxication.
please.
Yes.
Your sister says that was not a live issue at trial, and therefore, even if it were error, it is of no consequence.
Well, it certainly was a live issue at trial. I mean, for one thing, the Commonwealth used his drinking issues as state of mind evidence. But more importantly, I mean, this was a alcohol-fueled, spontaneous, unplanned outburst. And I mean, there was a thrust towards manslaughter, but in all frankness, Your Honor, the evidence is once, from the defendant's own statement, by the way, if, assuming that, you know, the victim came at him with a knife, once he takes that knife away, you know, kind of, I mean, and on the instruction, the jury's gonna, self-defense falls away, but not provocation. And provocation in this case and the intoxication are pretty closely, I mean, they're not the same thing, but they're together. I mean, I think it's a matter of common experience or knowledge, certainly, or understanding that someone who's intoxicated might be more easily provoked or fly off the handle. I mean, that's just, so it was a very much a live issue, and defense counsel drove that point home in the closing argument. So the intoxication instruction, again, this is somewhat difficult to understand, but counsel asked for the 1999 model jury instruction, and if you read through it, that one sentence is missing. You know, you can take the intoxication and apply it to whether or not he acted cruelly and atrociously. So, I mean, it's probably an oversight. It's not objected to, but I think I say the case is on all fours with Rotowski, and I say Rotowski controls this case. Just like Rotowski here, the very brief one-sentence instruction went to knowledge and intent. It comes after second-degree murder. It's not linked, contrary to what the Commonwealth says. It's not linked to the first element of extreme atrocity and cruelty. And so, I mean,
Not only did the counsel not object to this, counsel didn't ask for that, that instruction that way.
Correct, but if you look at and it's in my appendix, Justice Lang.
I'm sorry, I thought counsel had asked for it but not objected.
Well, it's not in the written instruction, which if you compare it line for line to the 99 model instruction, everything's there in what trial counsel submitted except for that. And I
Gave pretty close to what counsel requested.
well, she gave an instruction, that one sentence instruction I laid out in the brief that really some 20-year-old cases say that was sufficient, but there are these new, Lutowski and this court recently in Berry and some Schwack stuff from last year, I'm butchering that name, but in Walker. It's, you know, and even that instruction has been required by Gould and Perry and some of the other cases for 30 years. So
What was the evidence that he was actually intoxicated at the time of the stabbing?
well, There was evidence from the cab driver that when she dropped him off that, that he had been drinking. I think the victim's mother, who had been out with them that night, she said that he drank the whole, he's drinking all night.
Beer.
Well, he's drinking all night. So, and then his own statement, I think, in the holding cell, he makes statements. He says that, I was out drinking, and she was getting, she wasn't, the victim was not, particularly pleased by his drinking habits. And so there's evidence there that he's intoxicated. And also the police say that he's glassy-eyed. I mean, he can talk, but I think a person who's accustomed to drinking alcohol can be very much intoxicated and still kind of muddle along, and that appears to what he did here.
Was any issue raised as to the voluntariness of his statements to the police?
I think that was a subject of the motion to suppress, but voluntary only in the sense that trial counsel argued below that there was a difference between Officer Cepeda's Spanish and Mr. Gonzalez,
No, I'm
even
not in
though,
connection with the intoxication. How inebriated was he?
well, at the suppression filing by trial counsel, it's not accentuated or really driven home. And I didn't brief it in the appeal as a separate issue.
And did the police say that he appeared to have alcohol on his breath when he was arrested?
Well, glassy-eyed, he's glassy-eyed, and he's a little bit unsteady on his feet.
The police at the time of the arrest said he was
Oh,
drunk.
absolutely, absolutely. I think Officer Cepeda testifies to that. It might even be another officer that says the same thing, because there's one officer that directs him to step into the kitchen. There's a little exchange. The first officer realizes that Mr. Gonzalez is speaking Spanish, so they get Officer Cepeda, and he arrives pretty quickly. So I just think, Witowski applies the substantial likelihood standard of review, and I say this case is on all fours with Witowski. So I would ask the court to award a new trial on this issue.
Could you just help me understand what it was that was his defense at trial?
Well, defense was
Theory of
kind of
defense?
Well, it was the defense that, the Commonwealth was going to have some problems proving the identity of the assailant. That was sort of, I would describe that somewhat as half-hearted, but it was really mitigation.
How was it argued in closing?
Well, it was argued that she came at him with a knife. He took the knife away. I mean, that argument, quite frankly, Justice Spina, is not going to fly. But what really was live was provocation, that he was angry outbursts fueled by alcohol. And I'll get to that in the 33E argument. But it's just a provocation case. It's a manslaughter case. And it's trying the case to a manslaughter verdict, in my humble opinion. Possible, hoping for that. Or a second.
With regard to the failure of intoxication instruction concerning extreme atrocity or cruelty, why would that get you any better than second degree?
Well,
Or give the Commonwealth the opportunity to accept second degree or new trial and pursue first degree?
I think, and I don't know that I'd have really a case to back me up, but I think the omission here had a negative impact on the possibility of a provocation finding. That the drunkenness, as I said earlier, the drunkenness and the provocation, they seem to sort of go together in this particular case, particularly where, by the way, Your Honor, the 33E cases talk about an alcohol-fueled explosion in cases where this court has taken the first degree down, if I may say, a notch or two. So with that, I'm getting low on time. I think this is an appropriate case for 33E relief. Even though the jury rejected provocation, the entire thrust of the evidence was that the victim came at Mr. Gonzalez with a knife, and that and he got smacked in the face with a bottle. So even though provocation is rejected, the defendant's, that comes from the defendant's statement. There's nothing that contradicts that in trial evidence that's worthy of consideration, according to the cases.
And what kind of marks did he have on his face?
Well, he had a cut on his nose, which was bleeding when the police arrived, and continued to bleed at the police station. Also, a fat lip. So, he got hit in the face with something.
Was it a fresh fat lip? Or?
Oh, yes. Yes, Your Honor. Very most definitely a fresh fat lip. Yeah,
Described as an angry-looking.
yeah, no prior criminal record. Commonwealth was in a case 30 years ago, McDermott, there was a problem with a glue-type problem in the instruction. This court took McDermott's case down to a second. There's no first Cooning factor here. Defendant apologizes for what he did. He helped the victim back to bed. He's the one that called 911. So these mitigating circumstances, this case is more like the Colleran case I cited in my brief in Caldwell, and this case is nothing like the utterly savage, depraved callousness that you find in the Anderson case and in the Rodriguez case. So with that, Your Honors, I'm going to rest on my briefs with regard to prior bad acts and with the dying declaration.
Thank you, sir.
Thank you, Your Honor.
Good morning, and may it please the court. Hella Sachse on behalf of the Commonwealth. This court should affirm the defendant's conviction for murder in the first degree. I will, as my brother, begin with the suppression issue here. The defendant's right to silence was not violated when Officer Cepeda encouraged him to tell what happened after the defendant made a spontaneous comment in the holding cell. The trial testimony here does differ from the testimony at the suppression hearing. Nonetheless, this court should consider, limit its consideration to the suppression testimony. Because this case is under 33E review, the court will, of course, review the entire case. However, it cannot simply pick and choose which version of events to believe. And something like this should be litigated in a motion for new trial or at least in an evidentiary hearing that allows to establish what the facts actually are that
What would that accomplish? We have a motion to suppress evidentiary hearing, we have a trial. Hearing the same thing a third time is going to clarify what occurred?
I think if Officer Cepeda were confronted with both versions of his testimony, he might be able to clarify what he indeed meant to say at trial, or whether there was a mistake and which version is the one that he accurately recalls, and then a fact finder could make a determination of which version of events is the one that took place. Yeah.
Have you gone back and checked with the court reporter and made sure that the court reporter did not err in transcription?
I did not talk to the court reporter. I have conversed about it with the trial prosecutor, who confirmed what the transcript reflects.
That there's a difference between the two, you mean?
Yeah, that's correct, yes. The questioning at trial indicates that the prosecutor was expecting the same answer that was given at the suppression hearing, and it simply came about differently.
But but didn't make any kind of an effort to try to correct it, seeing that it could be seen as an invocation issue.
No, and that is because it simply isn't an invocation.
No, but I mean, you could see it as him having said no, he didn't want to talk.
Correct. There was
In
no
a way that it didn't happen at the motion to suppress. So nothing was made of this by anybody at the time. It was
That is correct, and it would have been defense counsel's responsibility to object.
Came out. You just said that the prosecutor told you that he was expecting the same thing to be said.
No, that
at
is what the-
trial as was said at the motion to suppress. And when it didn't happen, wouldn't you have thought that the trial prosecutor could have clarified it right then?
No, what I said is that the transcript reflects that his questioning
I see.
anticipated the
This
same
is because
answer.
you had said that you checked with the trial prosecutor.
Well, after the fact, he confirmed to me that the testimony that is reflected in the transcript is accurate. That is what he confirmed.
Did the judge at the motion hearing find that the defendant was in custody at his home when he was being questioned?
He was eventually placed in custody
I
at
know,
his home.
but at the time he made this statement,
He was not in custody, no.
so would that matter? Because if he's not in custody, Miranda doesn't kick in, even though he was given Miranda.
That is correct, and he, regardless of the Miranda status, the defendant continued to speak with Officer Cepeda, and he answered the same questions he had answered before, and continued his conversation. And if we're focusing on the trial testimony now, up to the point where he learned that the victim was indeed still alive.
Okay, I'm sorry, you said he was not in custody. Did the judge so find in the motion hearing, do you know?
I would have to double check that. I could get back to the court. I don't want to give you a wrong answer on that.
And what do you say with regard to why is this case different from Rutkowski, from Berry, with regard to the intoxication instruction?
Well, the key difference here is that intoxication simply was not a focus of this case. The evidence on intoxication is quite limited, and we have no evidence at all to the degree of the defendant's intoxication. Intoxication.
Right, you said there was no evidence at all.
very limited.
According to your brother, Mr. Officer Cepeda says he was glassy-eyed.
He was glassy-eyed. Officer Cepeda said, that's on page 97 of the transcript, he had a little alcohol smell on his breath. That is all.
And he was drinking all night, according to the victim's mother.
According to the victim's mother, and the cab driver testified that all three of the individuals she drove, the mother, the victim, and the defendant, were drunk. Well, it turned out the mother said she never drank anything that night, and the victim had a blood alcohol level of 0.05. So she would have still been capable of driving a car. So that determination that they were drunk is quite questionable. There's nothing on the record that indicates how much alcohol the defendant consumed. Officer Cepeda detected a little alcohol smell on his breath with some glassy eyes, but the defendant was able to maintain a conversation with the officer. He was steady on his feet. He was not confused. He was able to engage in conversation. So this is not a case where the defendant was so intoxicated that overwhelmed everything else. And the cases my brother relies on, Rutkowski and Gold, the mental ills, mental incapacities were the key evidence of the trial and focus on the defense, and that simply isn't the case here. The defense did not focus on the defendant's intoxication at all. Defense counsel here had the unfortunate position to have to reconcile the defendant's two statements that A, the victim was killed by an unknown intruder, and B, he committed this act in self-defense. So he had to work with these two differing statements from the defendant, and then he tried his best to urge the jury to consider mitigating factors of all kinds to reduce this to a manslaughter case.
But even as to the drinking, I mean, the confession that was played to the jury, I mean, he telephoned his roommate and left a voice message.
Correct.
And he says that he'd been drinking. And that, other things he said that, were not so attractive, but he'd had problems with a Puerto Rican woman and had stabbed her. But clearly he says he had been drinking. So there was evidence throughout of alcohol consumption.
Well, alcohol consumption, but we don't know how much. And he'd been
And that
drinking.
he'd had, and the prior bad acts that one of them that was challenged was the victim's mother's testifying that the victim had complained of his drinking.
Correct. She had complained of his drinking before, and there was one incident on several days earlier where the victim had refused to go home with the defendant because he was so drunk. She wanted to allow him to sober up. Well, that did not happen on this occasion because she went home with him. They were happy as they were getting out of the car, chatty, celebrating Valentine's Day. So
what is the relevance of that bad act that you offered? You offered it as a bad act to show, and it got a limiting instruction.
That is
that
correct.
it was the source of the conflict between them,
Well,
which
there was a
suggests that
conflict.
that on this night, she was upset that he was drinking all night.
Yes, so she was upset about his drinking. That does not mean that every time she was upset or every time he drank, he was indeed drunk. There's no evidence to that effect. There's evidence that on one occasion he was drunk and she detached himself from him, gave him time to sober up, and then went back. But there's no evidence at all about the degree of his intoxication on any other occasion, including the night of the crime. And with regard to 33E review, this court should not exercise its power under 33E. This was a brutal crime in which the victim suffered 8 stab wounds, 4 of which were independently fatal. She was in pain throughout, as the medical examiner testified. She lived for about 4 hours, afterwards undergoing serious surgery, removing her spleen, removing parts of her lung. She tried to fight the defendant off, resulting most likely in the cuts to his face and a fat lip. He left her in a pool of blood while he mopped the floor, and these facts support a verdict of murder in the first degree on the basis of extreme atrocity or
What was the
cruelty.
Commonwealth's theory as to what triggered this? Everything was hunky-dory when they came home. Something happened. What was the Commonwealth's theory as to what triggered this particular event?
This was a brutal act of domestic violence.
Well, we know that, but is the view that there was no trigger to it? It just, he turned a pleasant evening into a killing?
Well, there was evidence that the victim had been unhappy about the fact that the defendant had been drinking before, though we don't know how much he had been drinking. But that is a possible trigger that could have simply resulted in her death at this time. Thank you.
All right, thank you. We'll take our morning recess.